and safety type of issues. The 2014 Act provided very strongly that workers were protected from penalisation if they made a protected disclosure, and penalisation were actions such as dismissal, failure to get maybe a promotion, disciplinary action. And where a worker demonstrated and was able to prove that they were penalised before the Workplace Relations Commission, who dealt with these claims, they could secure up to 5 years remuneration, which is a significantly greater award than can be made under other pieces of employment legislation. But significantly for this morning, because we're going to focus quite a bit on internal channels of reporting and reporting policies, employers in the private sector were not obliged to have even a protected disclosures policy in place or a process to handle protected disclosures. Employers in the public sector were. And really, that is a very, very brief, high-level overview of the 2014 Act, but a good springboard for us.
And we don't have new legislation yet, Liz, but we do have draft legislation. We have a bill that's working its way through the legislative process. It has been informed and is largely driven by our membership of the European Union and by the provisions of the directive which underpins it. But in very simple terms, Liz, what is going to change once the new legislation is enacted, assuming, and all of this is qualified by the fact that we're assuming the new legislation will be fairly close to the provisions of the bill, which we're quite familiar with already. So what are the kind of the high level changes, Liz?
Okay, so these changes are driven by a change in EU legislation. So within the EU, there was a lot of discussion and debate about harmonising the protections for whistleblowers across the EU so that each individual country wouldn't have its own individual rules and regulations. And also within the EU, there was really the objective that was agreed, which was that there would be a common minimum protection to persons who reported breaches of EU law. So not domestic law necessarily, but EU law.
And there's specific provisions of EU law around things like public procurement, financial services,
GDPR, terrorist financing, and such. You're absolutely right. But significantly, the directive did say that employers in the private sector had to have a channel. It had to have a process which set out steps that an employee and a worker could rely on if they were going to make a protected disclosure. So it's very prescriptive. And we are expecting the bill to be passed because obviously there's an Irish bill in place to reflect the provisions of the directive, and we're expecting it to be passed before the summer recess, but we've no certainty on that.
Okay, so just to summarise that, driven by a desire to harmonise EU laws, require employers to put a process in place, which we're going to talk a little bit about as well, particular and specific provisions for certain breaches of European law around things like procurement, financial services, and there's a list of those, quite a short list. The deadline for implementation of the directive for all member states, not just Ireland, but for all member states, has passed. It passed last December. So we are in default, the government's under pressure, and we expect the legislation to be passed, probably in its current form or something very close to it, the current draft bill, if you like, before the summer recess. We'd hope. So the changes then, Liz, are largely focused around the requirement for a private sector employer, it's distinct from a public sector employer who always had an obligation to have a reporting panel. So tell me a little bit more about the reporting channels and what's provided for in the draft legislation or in the bill.
Okay, so as I mentioned, the directive and the bill are quite prescriptive about what these channels should look like. I do think it's important just to note that employers in the public sector have had whistleblowing policies in place since 2014 because they were obliged to do so. I do believe that employers in the public sector will need to update their policies quite significantly to reflect the prescriptive steps in these channels. So that's sort of a note of caution for employers in the public sector as well. So in terms of the channels, this is certainly the area of greatest challenge, I think, for employers in the bill. And what we're going to focus on this morning is an internal channel. So it's the channel for workers to raise concerns internally in the employment. We're not going to focus on the other channels that are in the 2014 Act. They are also in the bill, but these are channels such as workers in the public sector who can report to a minister or a prescribed person. We're not going to deal with those this morning. We're simply going to talk about the workplace.
Yeah, like going to the Health and Safety Authority with the health and safety issue, or the Data Protection Commissioner with the GDP or data privacy concerns.
Absolutely.
We're focusing just on the internal ones and the obligations on all employers, but what will become important for private sector employers in particular.
Private sector employers because they started from scratch, for public sector employers because they will need to review their policies. And also one of the channels, of course, that we're not going to cover this morning, but bear in mind, is a channel where an employer can go externally to the organisation, to the media, but we're not going to cover that because we just simply don't have time. So in terms of internally within the organisation, so if you're an employer with over 249 is the figure, I'm going to call it 250 for ease. If you've over 250 employees, once the bill is enacted, there may be a time period for you to put your policies in place. We're not 100% sure of that, but you will have an obligation to have a policy, an internal disclosure channel policy in place very, very quickly, pretty much immediately. If you're an employer with between 50 and 249, 50 and 250 employees, then you have a derogation until 2023. So you don't have to be immediately concerned about putting this channel in place.
But it's coming down the tracks. So
it is coming down the tracks, absolutely. So what your channel should provide for, and we are referring to it as a channel, it can be a policy, but it's effectively a policy and a procedure, but just bear with us while we call it a channel because that's what's contained in the legislation. So first of all, disclosures can be verbal, or they can be in writing, or indeed the person making the disclosure, who's called a reporting person now in the new Act, they can request a physical meeting with the employer. The channels need to operate in a secure manner. And this is very, very important that all the GDPR obligations that the employer has are followed and are taken note of and designed into the channel as such.
So the protection of confidentiality, the protection of the information being reported is really important. Yes.
It's really important. And we'll be talking about that in slightly more detail in a minute. The identity of the disclosure cannot be disclosed without his or her explicit consent. And again, we'll talk about that in a little bit more detail. But I suppose what I would really like you to take home from this session today are two concepts from the channel. The first is there is an obligation on the employer to diligently follow up. Now, that's actually defined in the bill. And what it means is that the employer is obliged to take an action to assess the accuracy, address the wrongdoing, to make an inquiry, to investigate, prosecute, or close. So now, in 2022, employers have a proactive obligation to diligently follow up. And as I say, they're the steps, and we'll talk about investigations in a little bit of a while, but just bear that in mind. Those are the obligations contained in the bill. You must demonstrate that you've diligently followed up.
So not only must you diligently follow up, you must be able to demonstrate that you diligently followed up. So if it's a short assessment, that needs to be recorded and noted.
Correct, yeah. Absolutely correct. And the perception is very important here. The other message that I think is important for us to talk about for a couple of seconds here this morning is the whole notion of feedback. So previously a person would make a protected disclosure and there was no obligation on the employer to tell that person what became of their protected disclosure. Was it investigated? Was there was there a financial coup for the company as a consequence of them making a disclosure? Was a person disciplined or whatever? They had no right to know what happened. The protected disclosure, they were really the messenger. Now an employer must tell the reporting person what they've done. And again, this whole notion of follow-up is one which is pinned down in a definition in the bill, which says that feedback is defined as giving the person who made the protected disclosure information on the actions envisaged or taken as follow-up and the grounds for such follow-up. So again, it's quite prescriptive, and I think it's very well worth your while having a look at the bill and having a look at those definitions.
So there's a lot of transparency involved.
Absolutely, and I think that's the objective.
Yeah.
It is different. It is a change of culture compared to what we've been used to.
And there's quite a bit of work involved in this for employers.
There certainly is, because not only will an employer have to have the nice document, the channel, they will also have to have the processes underpinning that to make sure that their obligations are actually translated into reality for the person making the disclosure. It isn't. I just want to make one point before we move off this, Melanie, which is that an investigation is certainly one of the steps in the diligent follow-up. And in our experience, in most cases, our clients do carry out an investigation, but it's not always necessary. Just to bear that in mind, because employers, when they think about protected disclosures, immediately jump to investigation. It might not always be necessary to have an investigation, but it is one of the steps.
That's it on the channel.
That's it, really, I think, on the channel. It's about feedback and it's about diligent follow-up.
I did see a policy from a US client last week, and their policy committed to an initial assessment and then, if necessary, an investigation. And in the particular matter in which I was involved, an initial assessment found that there was no need for an investigation. And we noted that and communicated it back to the employee who felt he was blowing the whistle. And that's the kind of thing that's envisaged by this, but it's important to go through the motions and to feed that back.
That's absolutely correct, Melanie. It's the point you made about it. It's about transparency. And I can't emphasize enough from our experience of dealing with employer clients who have had protected disclosures, the importance of the initial assessment, because employees will often trigger and call a complaint a protected disclosure, but it might not actually fall within the protections of the legislation unless it falls within the definitions contained in that. So an initial assessment is absolutely critical before the employer starts to take some action on foot of it.
Just to remind everybody, there's a question and answer box on your screens. If you want to feed some questions in there, we've left some time at the end to deal with those. So we should have plenty of time by the time we get to the end to deal with them. So if you have some questions, put them in. I will be able to see if they're ones that we dealt with by the time we get to the end, but hopefully we will let them start. We should have some time to deal with some of the questions. Can't guarantee we'll get through them all, but put them into the Q&A box at the bottom of your screen and we'll come back to them. Liz, just a couple of things on the channels. So the channel is about having a process, and it's always a good idea to have that process in a policy document, whether it's a process around bullying or a process around a grievance or a process around a disciplinary process. But for organizations who have existing channels in place, and they are, for example, hosted out of HQ in California or somewhere else, does that work?
Now, this is an area where there's been quite a bit of discussion and debate, Melanie, so it's a bit of a hot topic amongst people who are watching the protected disclosures legislation. So the general consensus, and this may be subject to change, but the general consensus and what appears to be practical is, say, for example, if you're an American multinational with 300 employees based in Ireland, it is fine to have your hotline or your the mechanism by which employees can make the disclosure in the US or in any other country that you wish. That's the making of the complaint, raising the concern. However, when it comes to actually the Irish employer's obligation to deal with that concern, the channel should be an Irish channel. And the logic behind all of that is that for many American multinationals, they will be subject to the rules of Sarbanes-Oxley or Frank Dodd. So they will have had a history of having hotlines in place, probably outsourced hotlines in some cases. And so, what this act should not do is create layers of procedures. The idea is we have one procedure to deal with Irish, objectives, European objectives, and the objectives maybe of countries who have HQ in other jurisdictions. But then what should happen in an ideal world is that disclosure is communicated back to the Irish entity who uses its own channel to deal with them. Now, some commentators that I've been listening to on podcasts have said that you should allow the employee the choice, because sometimes an employee based in Ireland might want their concern dealt with by HQ. If it's a HQ concern.
Exactly.
Yeah.
Or if it's something about somebody senior in Ireland.
Exactly.
Yeah.
Exactly.
Yeah.
But that should be at the option of the employee, the worker, and not the company necessarily.
Okay. And Liz, this is, you know, a lot of work, but fine for the Mason, Hayes and Currans of this world, where we have structures and policies and procedures in place, and everybody's a laptop and will see the policies. But what about organisations that don't have that structure but might meet the headcount threshold? How do they then manage an internal mechanism? Or is there help they can get?
There's certainly help they can get. And first of all, if you've less than 50 employees, you know, in the private sector, bar one or two with specific anomalies, you don't have to have the internal channel. But let's assume we're talking about a slightly bigger organisation here, like a hotel. A hotel is a good example.
A shop, a security company, a cleaning company.
Exactly, exactly. So there is a provision in the section of the Act that deals with this, or the bill, I should say, that deals with these internal channels, which says that they can outsource that function. So they can buy that function effectively. But what is important for that hotel, for example, who's engaging an outsourcer, is that they should check that the person who's providing the outsourcing service has in place the necessary security steps, has in place the steps to do the diligent follow-up and the feedback, because ultimately it's the responsibility of the employer to ensure, to take reasonable steps to ensure that the process is compliant with the legislation.
So yes, you can outsource, but the onus is still on the employer to make sure that the outsourced service provider is complying with obligations under the legislation once it's enacted, obviously, around the security of the channel and that the organisation doesn't, I suppose, outsource the responsibility for delivering the feedback and diligently following up.
Yes, and I would imagine that most outsourcing companies, and certainly ones that we've come across, they liaise very closely with the employer, because obviously the employee is talking about something that's going on. I saw Mary, you know, stealing money from petty cash, or, you know, the procurement practices in my organisation are ones I'm not comfortable with. So the outsourcer is going to have necessity engage very closely with the employer, because the employer will be giving the outsourcer specific information that they should be looking for if they're going to deal properly with the disclosure.
And is the outsourcer, is any organisation then, and we've touched on this a little bit, but what I want to come back to it is there an obligation, Liz, to actually investigate Mary stealing money from the till, or my employer is pumping effluent into the local river, or whatever it is? Is there an obligation to investigate that? Because there'll be different levels of seriousness, if you like, in relation to disclosures that are made.
Absolutely. And it goes back to what we were discussing a little while ago, which is that sometimes there is no requirement for investigation. It's very clear what happened. And the employer can find out if something untoward happened very quickly without necessarily engaging an impartial investigator, thinking about terms of reference, thinking about interviewing witnesses, and starting that very complicated process. There may be, for example, if you're thinking about procurement practices, a way of interrogating your own computer systems to see if there are certain suppliers who are getting a higher percentage of commission on products that they provide to you. So it might not always be necessary to have a full-scale investigation, but normally there are obviously some inquiries to be made if an employer does receive a report.
Yeah, it's interesting because I know I keep saying that, but 10 years ago, the word investigator rarely came up for us, but it's a whole industry now. Like, what kind of an investigator might an organisation need upon receipt of a disclosure?
Yes. So obviously, if a person in the workplace is doing something untoward, it is reported in the context of a protected disclosure. There is an investigation. There could be disciplinary action taken against that individual. Indeed, there could be disciplinary action taken against a person who makes a very spurious protected disclosure. But I don't think it's always good to think about disciplinary action, which can sometimes be the end point. And what I always suggest to clients is, if the complaint is about your financial practices, bring in somebody who's an accountant. If your complaint is about health and safety, bring in a health and safety consultant. And then HR can springboard off that investigation if there is any disciplinary issues subsequently.
So match your investigator to the issue. If it's environmental, get somebody comfortable with environmental issues. If it's corporate governance related, or if it is financial, get somebody with those skills internally or externally. I mean, sometimes those skills will be available internally and there won't be a conflict. And sometimes that won't be the case, and it'll be necessary to bring in an external investigator, an accountancy practice, a law firm, maybe an environmentalist, a health and safety consultant, to match the investigator to the issue.
And on that point, Melanie, there's nothing in the bill that gives employers any guidance as to what the investigation should look like. And it's similar. We all know that from the code of practice and discipline and grievance. So you're really back to the fundamentals of a fair investigation.
And we have the same issue with, as you say, disciplinary issues, grievances, bullying complaints, harassment complaints. Should the investigator be internal? Should the investigator be external? How do you deal with perceived or real conflicts in relation to the investigation?
Yes.
And there's no clear answer to that. It's going to have to be fact and situation specific. Yeah.
Absolutely.
What then lays about timeline? So an organisation receives a complaint or a disclosure, and there is this obligation that we now know to diligently follow up, whether that means assess, investigate, feedback.
Mm-hmm.
Are there timelines in the legislation?
There are, Melanie, and there's two time periods that an employer needs to be aware of. So first of all, the disclosure must be acknowledged within 7 days.
Okay, so an acknowledgement within 7 days.
And there must be feedback given to the employee in a time frame as soon as possible, but not exceeding 3 months. So 7 days and 3 months are the backstop time periods that employers should bear in mind.
It's very tight slips. If there's a big corporate governance issue or a big financial fraud, 3 months, it might even be feedback around the progress. It doesn't necessarily have to be that it's finished.
No, it doesn't have to be finished, exactly, Melanie. And you and I advise employers consistently, particularly where they have time periods in, say, their bullying and harassment procedure or their grievance procedure. I'm not a great supporter of those time periods because I think you can give yourself a bit of a rod to beat yourself with. But of course, it's always sensible to go to the employee and say, I thought I could get back to you by the 1st of June. It's not now possible because I'm doing A, B, and C. I anticipate it to be the end of June, and that's completely fine.
And if there are terms of reference for an investigation, which there don't have to be and there may not be, but if there are, it might be in there.
Great.
Okay, Liz, shift the dial slightly then. I want to talk about the disclosure, the employee, the worker, and we'll come back to who the disclosure is in a couple of minutes. But let's assume for these purposes, it's an employee makes a disclosure or comes across something. Very often, individuals, whoever they are, don't want to stick their head above the parapet for fear of penalisation or retaliation, which is a great word the Americans use. We don't use it as much, but I like the word retaliation. What is the situation now around anonymous reports?
Okay, so anonymous reports are very difficult because obviously if the anonymous report is somebody contacting the employer saying, I saw, Jane doing X to Joe. It's very difficult for the employer to do anything about that if the disclosure is simply based on what one person saw. So in those sort of circumstances, it is appropriate for an employer to say, look, I really can't progress this unless you officially make a statement or if you are prepared to come on record about this. It's different if the anonymous disclosure gives some evidence. So if you look in X, you will find Y, all right? Then that allows the employer, without needing to involve the individual who made the disclosure, to go away and check the accounts or the computer system or whatever the case may be. So the bill doesn't change that obligation. So there's no obligation on an employer to deal with an anonymous complaint, but they may choose to do so. That's what the bill says. But it also does protect people who make anonymous disclosures in that if a person makes a disclosure anonymously and is subsequently identified, they get the full protections of the bill.
Which makes sense.
Which does make sense completely. And I would like to make just one point about confidentiality. I referenced it earlier. So you will be aware, if any of you have had disclosures under the 2015 Act, that there is an obligation on the person to whom the disclosure is made to maintain the confidentiality of the person who made the disclosure. But under the 2014 Act, there was very big carve-outs out of that. So if you as an employer said, look, I need to expose your identity to carry out an investigation, or I reasonably believe you didn't mind me using your name, or if I took reasonable steps to protect you, but unfortunately they weren't enough, that was fine. There was no penalty to the employer. Now the focus has shifted, and employers are now obliged to design and establish their channels to ensure the confidentiality of the identity of the person making the disclosure and any third party mentioned in the disclosure. So again, that's the third takeaway.
Yeah.
If we're talking about takeaways today, that is the third. Very, very strong onus on employers to maintain confidentiality.
Confidentiality,
Sacrosanct. Pretty much.
And Liz, I mentioned there that this isn't just about employees making disclosures. So that's changing.
That's changing, yes.
That is changing.
I mean, the 2014 Act has always been about workers. So today, an employer is obliged to ensure that, employees, contractors, agency workers can make disclosures in the workplace. Now there's going to be a radical shift under the Act because we will have people who are non-employees who are protected from penalisation. And remember, the penalisation award can be up to 5 years remuneration. Obviously, that's relevant to the worker. But persons protected now include volunteers, shareholders, and candidates. And if those individuals successfully argue that they were penalised in some way for making a protected disclosure, they can be awarded up to €15,000, which is the current sum. If you think about it, the people under equality legislation can secure if they feel discriminated in a candidacy type of process, in a recruitment process.
And while not every organisation will have, volunteers, lots, and I can think lots of our own clients have volunteers and shareholders who come across something and want to raise it. And they will have to have access to the same channels as well.
Absolutely.
Okay.
Yes.
Okay. There are a couple of other small things we need to be aware of. Penalisation is that's been expanded. What constitutes penalisation has been expanded a little bit.
Yeah. So as I mentioned at the beginning of our talk this morning, penalisation it typically constitutes what we all think about when we think about penalisation in the workplace. So a demotion, a dismissal, those types of steps. Penalisation now has been expanded quite a bit, Melanie, and it now includes, so penalisation could comprise of an employer withholding a training opportunity for a person. And this is, I think, going to be quite a fraught one, where an employer sends the employee for a medical assessment or a psychiatric report. That can constitute penalisation. And
is that something you and I see in practice all of the time? Because it's easy to say, well, Ted is making that disclosure because he's not well, or and let's have him medically assessed.
Absolutely.
And it's something, unfortunately, we see almost every day.
Absolutely. And I think what it may lead to, and hopefully it won't be abused, but what it may lead to is where an employee is resisting attending for a medical or psychiatric assessment as being proffered as the reason why they're not going to go for it. But so employers need to be more careful now about sending people for psychiatric and medical assessments. Employers should always exercise care, because obviously we have the case of the central bank where a person was sent for a psychiatric assessment without knowing why or what the employer's motivation was. But employers now need to be able to, I suppose, if they're challenged, withstand the scrutiny about why did you need this medical, why did you need the psychiatric assessment, and be prepared to objectively justify it. Also, Melanie, a negative performance review can constitute penalisation.
You can see how that can happen in the real world, but you can also see how an employee might say, even if the reasons are wholly unrelated, might say, well, you marked me down because I made that disclosure. So it's it's back to the burden being on the employer, the reviewer, to be able to justify the meet some rather than meets all ratings.
Yeah, and actually on that point, on the burden of proof, it's prescient that you should bring it up, because the burden of proof has now shifted. So now, when the bill is enacted, the burden of proof will be on the employer to prove that the action taken, the alleged penalisation, so whether that's sending somebody for a medical, giving them a poor performance review, terminating their employment contract, was not taken because the person made a protected disclosure. The burden is the flip of that at the moment. So the burden of proof is on the worker. Now it's on the employer to demonstrate that the action taken was not because the person made a protected disclosure. So they're quite significant changes now. I mean, I think that the focus really is to further protect people who make protected disclosures. and also to ensure that the person's confidentiality is maintained and that they're not penalised. These are all sort of bolstering, I think, the protections to the reporting person, as we'll now call them once the bill is enacted.
So, Liz, the 2014 Act, there are almost 30 lawyers on our team. We've done a fair bit of work in this space, but not huge amounts. It didn't change our lives or anything. And some of that might have been, or it might be explained by the fact that, you know, it was hard to make a disclosure in an employment context that fell under the ambit of the legislation because there was this carve out, which I'm going to talk about. So just in very simple terms, the 2014 Act, when it was talking about relevant wrongdoing, so what is covered, what types of disclosures are covered, it talks about and that an offence had been or was about to be or was likely to be committed. It talked about breaches of health and safety legislation in relation to which somebody would be endangered. And then it talked about failure to comply with legal obligations, but there was a carve out, right? And that carve out was anything arising from a worker's contract of employment or another contract whereby a worker undertakes to do or performs personally any worker services. So that kind of took out of the arena grievances, and maybe that's the reason. Like I said, we did a fair bit of work in the space, but it didn't radically change anything in the way that we thought maybe it might when the legislation was enacted. So the new bill, once it's enacted, has two additional grounds. So one of them is a breach, but it's a breach of specific EU provisions around the things we've been talking about, financial services, procurement, those kinds of things. But then it also carves out a matter concerning interpersonal grievances exclusively affecting the reporting person. So grievances about interpersonal conflicts between a reporting person and another worker. So those kind of individualized grievances are expressly and explicitly carved out of the application of the legislation. But that still leaves a whole lot of other employment related issues that could potentially be caught, particularly if the issue is in relation to more than one person. So if I think about interpersonal grievances, I think about complaints of bullying and harassment. They are rarely, which might be surprising, but they are rarely about one person. They're rarely Ted is bullying me or Ted is harassing me. They're usually about a few people, and maybe that's because somebody's a bystander, didn't do anything about it, or somebody got involved or laughed at the joke. They tend to be more, which potentially brings it in under this. But there was also a decision in December that, that has made a difference actually in an employment context. And that was related to an abattoir. Just tell us a little bit about that.
Yeah, so very quickly, Melanie, the plaintiff in that case was Mr. Barania, and he worked in an abattoir on a production line, and he made a complaint that the work was causing him injury. And his employer initially dealt with his complaint as a work-related grievance. And Mr. Barania wasn't very happy about that. And he took a case to WRC and he appealed it to the High Court, both of whom supported the employer, who was Ross Meats. And they said, no, this is not a protected disclosure because it's about Mr. Barania's own work situation. It doesn't have broader application than that. But Mr. Barania got leave to appeal his case to the Supreme Court. And in the Supreme Court, he ran the argument that he had made right through his proceedings, which is that I was making a complaint about a matter which really was around health and safety. And it wasn't just related to me because the repetitive work that I was doing, I think he was a boner or a meat cutter. There are lots of other people doing that work, and it is causing me to have, I think it was an arm injury that he had. And the Supreme Court looked at the 2014 Act and it said, we see the piece that Melanie just read about your employment contract not constituting a protected disclosure. But the issues that Mr. Barania are complaining about have broader application, and the Act does talk about public interest. So the Supreme Court agreed with Mr. Barania and said that he could deal with his disclosure and request and have the right to have it dealt with as a protected disclosure, because it was actually about a health and safety issue. And of course, health and safety issues are one of the relevant wrongdoings. Now, the section that you read of the Act was designed to deal with that particular case. And as Melanie said, the bill provides a matter concerning interpersonal grievances exclusively affecting a reporting person is not a relevant wrongdoing. Now, that's a very, very tight provision in the Act, but it's still, commentators think, might allow, well, what's exclusively affecting me?
Yeah.
So that's a very, very rigid test. And what some commentators say might be a better approach, and I gather the Attorney General may have looked into this, is because certainly Justice Hogan in the Supreme Court said perhaps the way around this is to make sure that employees need to demonstrate they have a public interest in making the disclosure for it to be a relevant wrongdoing. Yeah. That might be easier because that's clearly the spirit of the legislation. So I think we should wait and see on that point. But for us as employment lawyers and for you as HR practitioners, the practical lesson from all of that is, you need to be really careful to do the assessment that we discussed earlier to ensure that a person is making a disclosure which qualifies under one of the relevant wrongdoings. And I think employees should be educated as to what relevant wrongdoings are and what they're not. Perhaps that's by way of the policy. But also I think the employer should be really cautious about saying to a person, I'm not dealing with this as a protected disclosure because it's just really about your interpersonal issues. Again, the assessment would want to support that line of reasoning by the employer. Otherwise, it could be open to challenge for the reasons that Melanie and I just described.
Bullying issues are health and safety issues. And
this
we've certainly had a huge increase in the number of letters we are getting from plaintiff employment lawyers saying, my client made a complaint of bullying, that's a health and safety issue, that's a protected disclosure, and you're penalising him or her.
Absolutely, because the Code of Practice on Bullying sits under the Health and Safety Act. So there is these complexities, and I think we just need to be very careful about them. And I think the care should translate into designing the policy, communicating the policy, and having the initial assessment process.
There's some great questions here, Liam, so I want to jump to a couple of them, but one of them we touched on, and I'm going to come back to it. And it's about having a reporting channel. What am I actually doing the question? So it's about having a US, HQ in the US, because as you said, Sarbanes-Oxley, all of that, the US are way ahead of us in relation to this.
Yes.
So we over 300 employees, HQ in the US, East Coast, West Coast, doesn't matter, with a centralized hotline in place. You said the Irish company has to have its own channel in Ireland. So just let's talk about that for a second, because it has come up for us. Channel in Ireland, it's important to have a policy here that sets out the procedure.
Yes.
And the complaint is made here, even if it snakes its way across the Atlantic to Washington or California, wherever. And then it's important, you also said then it's important that the Irish organisation, the Irish employing entity, might not be an Irish entity, but the employing entity physically located here takes responsibility for diligently following up and whatever that means. So just maybe talk about that. So this whole notion of hotline managed out of the US, because that's quite common.
Yes, it is. And I think the scenario you've described, Melanie, is the one which will probably apply. So, and again, I would just caveat what I'm going to say, just to mention, this is not provided for, obviously, in the bill at all. So what we're looking at is commentary and people discussing this point. So the consensus appears to be that if you have HQ, let's say in New York, you can have a provision where your Irish employees are told if they have a disclosure, that's the hotline they need to contact. But when that contact is made to the US, and this happens today with our clients, when the contact is made in the US feed it back to the Irish entity, and the Irish entity then deals with it under their own internal channel policy, right? So they give the feedback, they diligently follow up, and all the rest of it. I did mention previously, what employers can do is that they can offer the employee either. So if the employee would prefer that the matter be dealt with in the US, in HQ, that can happen, or the employee can opt to have it dealt with by the Irish entity. But the fallback position should be Irish employee is entitled to the benefit of the Irish internal channel provisions. And let's not forget, the whole intent of this legislation is to encourage people to make protected disclosures. And, you know, what one commentary I listened to was saying, if you have a person who speaks Spanish and who's obliged to report to HQ in New York, for example, that person will probably want their complaint dealt with on the ground in their own local language, in their own local time frame. So it's all about making it easier for a person to make a disclosure and to protect them when they do.
There's another good question here, Liz, and it's one that we get asked in relation to employment policies generally. Given that this is EU driven, is it okay to have an EU-wide policy that applies to all of our employees all over Europe, or should we have an Irish specific one? And I think the answer to that's fairly obvious.
Yes, and as you say, Melanie, we deal with this query quite a bit. So of course, we just have a directive that has to be transposed into Irish law. Ireland has discretion around certain aspects of how that directive is transposed. So you should have an Irish policy, but I would envisage, if you're a European employer who say with employees in 4 different countries, your policy is going to be very similar with a couple of quirks.
Similar, but quirks. So, and like this happens with handbooks and general grievances all of the time.
Yes.
If you're going to have one policy covering all of your European jurisdictions, you need to make sure that you carve outs that are country specific, or else have domestic, like local policies and procedures for each of the countries, and make sure that that works in each of the other European jurisdictions as well. Some more great questions here, Liz. And this is one. So the Frankovic, first year in UCD or Trinity.
That was a long time ago for me. I can't guarantee I'm going to remember it. It's certainly a concept I'm familiar with. Yes.
The directive has passed. The transposition date has passed.
Mm-hmm.
The Irish government, along with most of the governments of the other European member states, have failed to transpose the directive on time. We're getting there, but we're a little bit like here in road there, and we've a bit to go yet. What about a shareholder or a candidate who makes a disclosure now? Are they entitled to the benefit of the protections in the directive, notwithstanding the fact that it hasn't been imposed?
Okay, so this is Law 101 Frankovic. So if they're employed by a public body or an emanation of the state, they are, because it's a directive and it has direct effect. If they're not employed by a public entity, then they will have to wait for the act. In saying that, any employer who receives a disclosure, we'll say from a shareholder or a volunteer, or indeed has a protected disclosure made tomorrow, they should really try to follow the spirit of the legislation. Because it's only a matter of time before it's going to be, the spirit of the bill, it's only a matter of time before it's going to be enacted, and you're better off being proactive. And the concepts in the bill are not hugely strange, even though it does present a leap forward, but the concepts around confidentiality and maintaining security and giving somebody feedback and following up, they're concepts that are in place today but not formalized. So I think you should definitely treat a protected disclosure made today within the spirit of the bill or the broader overarching umbrella.
Because it's good practice rather than because it's absolutely a legal obligation in the private sector.
Absolutely.
We have a few questions here, Liz, around disciplinary processes and slightly different ones. So first question is, what if I invite somebody to a disciplinary hearing, or we invoke a disciplinary process in relation to somebody? There's a complaint, whether you're investigation or disciplinary hearing stage, and that person then makes a protected disclosure.
Yes.
What does an organisation do then?
Yeah, very good question. So, and the answer is it depends. So if, for example, you've invited somebody to a disciplinary hearing because of a conduct issue or a performance issue, and they make a protected disclosure in relation to the employer's health and safety practices, that has no connection with the subject matter of the disciplinary hearing, you thank them for the protected disclosure, you assure them you're going to deal with it because you should be interested in any concerns that your workers make about their work environment, and you proceed with your disciplinary hearing. It's more complicated, of course, if you're inviting somebody to a disciplinary hearing because of, we'll say, poor performance around the way in which they manage the accounts payable process. And that person then tells you that their CFO has instructed them to do A, B, and C, that accounts for their poor performance, and that the instruction was contrary to the employer's legal obligations in relation to accounting rules. Then, of course, what you should do is potentially suspend the disciplinary hearing, try to deal as quickly as you can with the subject matter of the protected disclosure, at least up until a point where you can establish that the employee's performance or conduct hasn't been impacted by the subject matter of the protected disclosure. And then you can proceed after that with your disciplinary hearing. So no hard and fast rules, but really an employee telling you that they have a protected disclosure is really only relevant to the disciplinary procedure if the subject matter directly touches on why they are being invited to a disciplinary
Otherwise,
hearing.
keep them separate.
Yes, but assure the employee you're going to deal with the protected disclosure.
Okay, and then there's a couple of people here, Liz, asking about people who make vexatious disclosures are what are what's an employer's obligation as regards those disclosures? It's the same, but what if they're found then to be vexatious? And this was in the original legislation as well.
It was, and it's a really interesting concept because think about it this way. You can have a very, very problematic employee, an employee who's very difficult to manage, an employee who's quite demotivated, and they can make a disclosure, call it vexatious, but that doesn't mean that what they're disclosing isn't happening, right? So be very careful to rule out a person on the basis of they're just a difficult employee, it must be vexatious, ergo it mustn't be true. Because of course you can have a vexatious complaint that is telling you that something that is true. So there is a provision in the 2014 Act which effectively says something along the lines of if a person makes a complaint and their sole motivation wasn't, if you like, wholly pure and wasn't to have the disclosure dealt with, that they conflated it with another motivation, that any award that is given to that employee can be reduced by 25%. So that's vexatious, that's difficult employees. This has never, to my knowledge, happened in Ireland, but I think if you've an employee who's making untrue disclosures, and that's just not vexatious. That's sort of
it's beyond vexatious.
Beyond vexatious. It's a misconduct issue. Of course, you can deal with it as a misconduct issue, but you want to be very careful to ensure that you've made adequate inquiries to assure yourself that this person is doing it for reasons other than trying to bring to your attention a malpractice.
It's the malicious piece.
Malicious.
Yeah.
That's the word I'm looking for.
The word that our questioner asked to use here, which is a good word. Here's a good one too, and I think the answer is fairly straightforward. What about former employees? And if you think about the purpose of the legislation, 2014 was to protect from penalisation. Not really possible to penalise a former employee who makes a disclosure post departure.
Well, former employees are protected under the 2014 Act, and you could have a situation not only where I've been dismissed, I'm now a former employee, and I'm complaining that my dismissal was the penalisation. So that can arise.
Okay. And we're back to the anonymous piece here and the vexatious piece. What if you think, and I think this is a fairly straightforward answer as well, what if you think an anonymous report is vexatious and its exploration is very hard to do without alerting other people to the existence of this report? I mean, that's really about assessing it and still diligently following up, even if it is vexatious.
Absolutely. And and it goes back to the core, which is the difficulty with an anonymous report, is that if you're dependent on a person saying, I saw, I heard, I was in a particular situation, it's going to be very difficult to progress that without the anonymous person waiving their anonymity. But in other circumstances, it is, as Melanie said, about doing the assessment and seeing if to a large extent employers do need to treat every protected disclosure as being driven by integrity until they can form the opinion reasonably that it is actually a vexatious disclosure. But then the other point that I made previously should also be taken into account, which is that somebody could be very vexed. They could tell you about something in your organisation that is not consistent with good practice. They could still be right about that.
Yeah. There's actually an interesting one here that's just come in. What if the disclosure is made orally?
Oh, that's absolutely fine.
Yeah.
Disclosure can be made orally or in writing. And in fact, there is guidance in the bill which says that if a disclosure is made orally, it can later be transcribed. So it can be recorded or it can be transcribed in some way.
I think we might have one more question and we might have a look at the poll results and just comment on those. Are you going to hand those to me? So, sorry, one more question then, Liz. Oh, here are the poll results. I hope everybody can see those. Do you have a workplace policy in place in relation to protected disclosures? Interestingly, 83% of our respondents say that they already do. So well done, everybody.
Yes, very good.
So our attendees are an enlightened bunch and already have a policy and a procedure in place. So that's good. So 17% say no. Does the policy include details on how an employee can raise a concern? Again, 83% say yes. So everybody who has a policy has set out what an employee should do to make a disclosure or raise a concern. Does it provide for anonymity? So 80% says yes, it does provide for anonymity. So there's a few in there that have a policy, have a mechanism, a channel, as we're now going to call it, for making a complaint, but not on an anonymous basis. So that's going to have to be addressed by that or those organisations. Have you had any experience of protected disclosures in your company in the last 5 years? What do you think the stats are, Liz? Make a guess. How many percent say yes?
I would say it's quite low. I'd say it's less than 25%.
37%.
Oh, higher than I thought.
37% have had to deal with it. So it's higher than you thought. Yes. And that's interesting because it sometimes when employers put new policies and procedures in place, there's a little bit of a spike afterwards. So that may be coming down the tracks. Have you taken any steps to put in place a disclosure channel pending the passing of the new legislation? 33%, so a third of our respondents.
That's higher than I would have thought as well. Yes.
So this is something that's going to happen quite quickly.
Yes.
Will employers be given a grace period once the legislation passed to comply?
I think they have to be, Melanie. Again, there's no visibility in the bill, but there's quite a bit of legwork for employers to do once the bill is enacted. And so I think there will be a grace period for the first tranche of employers who will be affected, which are those who employ over 250 people.
And we've no sense of when in 2023 it will impact the 50 to 249.
We don't.
Liz, thank you. I hope everybody found that very informative. And I got through as many of the questions that I could. We are going to take a break for the summer because we're all off on our jollies. And I hope all of you are off on your jollies if we can get through Dublin Airport. We will be back in September. You're going to see a poll come up on your screen now. And if you take the 30 seconds to complete that, we'd be very grateful. It's more a survey than a poll. What kinds of things do you want us to cover? One of the things we'll have to cover very shortly is the gender pay gap reporting. So employers have a kind of a full workload this year between this protected disclosures, in upcoming legislation, the gender pay gap and the requirement, hybrid working, the introduction of statutory sick pay, amendments to kind of miscellaneous bits and pieces around employment, increase in parents' leave. So there's lots on the agenda this year, probably because we had a kind of a hiatus for 2 years. So it's a busy year for organisations, busy year for HR directors and managers and people managers. We will be back in September. If there's anything in particular that you'd like us to cover, please complete the survey. We will be covering gender pay gap. Again, we've done it before. There's lots of information on our website and in our e-zines around the obligations in relation to protected disclosures and in relation to gender pay gap reporting. Bear in mind that you have to pick a date in June to run your figures against which you have to then do a comparison. So all go at the moment, but thank you for joining us. Remember the survey. We will see you after the summer. We hope you have a nice break. For those of you who are taking a break, Liz, thank you. Thank you to our events team. And hopefully the next time we will see you back in person, or at least some of you in person. Have a nice day.
Thank you.